Sakeng v. People, GR number 2, 57805, April 12, 2023. Facts. Private complainant Jan Denver Pelosi recalled that he met Sakeng at a car repair shop where he was having his Mitsubishi Delica van repaired. Sakeng presented that he was looking for people interested to work in Australia as grape and apple pickers with a required placement fee of 300,000 pesos. Pelosi signified his interest to apply for the job. Short with funds, he offered his van as payment. Sakeng agreed, but required him to pay an additional 100,000 pesos in cash. To proceed with the application, Pelosi was made to fill out the forms. After filling out the documents, he gave them to Sakeng, together with his passport. Pelosi subsequently paid the 100,000 pesos in 3 installments. In all these transactions, Sakeng did not give him any official receipt. Pelosi recalled that Sakeng once brought him to Practice Agency, the office which supposedly processed the papers. He alleged, however, that Sakeng made him wait in the car. After Sakeng collected the entire amount of 100,000 pesos, Pelosi could no longer contact him. Hence, at around June 2013, Pelosi went to Practice Agency in order to personally inquire on the status of his papers and application for the job. To his surprise, he was told that he had no pending application with the agency. On account of this discovery, he went to the Philippine Overseas Employment Agency where it was confirmed that Sakeng had no license to recruit workers for overseas employment. To make matters worse, Pelosi found out that Sakeng took his Delica van from the car repair shop without his knowledge. Although the van was part of the payment for the placement fee, it was agreed that the vehicle would only be taken with the owner's consent. Nevertheless, Pelosi was able to recover it from a certain Ernesto Buya, the person who bought the vehicle from Sakeng. On cross-examination, Pelosi presented the deed of sale, official receipt, and certificate of registration of the vehicle to prove his ownership thereof. He stated that he did not authorize the owner of the car repair shop to release the van to Sakeng. He admitted his failure to inquire on the legitimacy of Sakeng as a recruiter for overseas workers. There was also no attempt on his part to personally visit the agency until such time when he could no longer contact Sakeng. In all the monetary transactions, no single receipt was issued to him as proof of payment. Lastly, he did not recall applying for a work visa. The last witness for the prosecution was Alberto P. Silvada, the mechanic who repaired Pelosi's Delica van. He testified that Sakeng requested to test drive the vehicle, but he no longer returned to the shop. According to the witness, Sakeng also promised his son, Ordona Silvada, a job in Australia. On cross-examination, Silvada confirmed that Pelosi did not authorize him to release the vehicle to Sakeng. He merely assumed that the latter was buying the vehicle from Pelosi. On redirect examination, Silvada reiterated that he did not actually hear Sakeng and Pelosi conversing about the sale of the vehicle. The defense waived its right to present evidence. Thereafter, the RTC convicted Sakeng for the crimes of illegal recruitment and estafa, but acquitted him of carnapping. Held. At the outset, we emphasize the rule that this court does not review factual questions, primarily because it is not a trier of facts and it is generally not inclined to re-examine and re-evaluate the evidence of the parties, whether testimonial or documentary. While this principle allows for certain exceptions, such exceptions are not present in this case. Given this, it is established that the factual findings by the trial courts in this case are generally binding upon this court. Thus, factual findings of the trial court, particularly when affirmed by the Court of Appeals, are binding upon this court. They are entitled to utmost respect and even finality, if there is no palpable error that would warrant a reversal of the lower court's assessment of facts. This principle necessarily limits the scope of review by this court over this case. Illegal recruitment, RA number 8042, or the Migrant Workers Act, as amended by RA number 10022, defines illegal recruitment in the following manner. Section 5. Section 6 of Republic Act No. 8042, as amended, is hereby amended to read as follows. SEC 6. Definition. For purposes of this Act, illegal recruitment shall mean any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, or procuring workers and includes referring, contract services, promising or advertising for employment abroad, whether for profit or not, when undertaken by non-licensee or non-holder of authority contemplated under Article 13F of Presidential Decree No. 442, as amended, otherwise known as the Labor Code of the Philippines, provided that any such non-licensee or non-holder who, in any manner, offers or promises for a fee employment abroad to 2 or more persons shall be deemed so engaged. It shall likewise include the following acts, whether committed by any person, whether a non-licensee, non-holder, licensee, or holder of authority. A. To charge or accept directly or indirectly any amount greater than that specified in the schedule of allowable fees prescribed by the Secretary of Labor and Employment, or to make a worker pay or acknowledge any amount greater than that actually received by him as a loan or advance. B. To furnish or publish any false notice or information or document in relation to recruitment or employment. C. To give any false notice, testimony, information or document or commit any act of misrepresentation for the purpose of securing a license or authority under the Labor Code, or for the purpose of documenting hired workers with the POEA, which include the act of reprocessing workers through a job order that pertains to non-existent work different from the actual overseas work, or work with a different employer whether registered or not with the POEA, etc. Jurisprudence parses out the elements of illegal recruitment in the following manner. To sustain a conviction for illegal recruitment under RA 8042 in relation to the Labor Code, the prosecution must establish 2 elements. First, the offender has no valid license or authority required by law to enable one to lawfully engage in the recruitment and placement of workers, and second, the offender undertakes any of the activities within the meaning of recruitment and placement defined in Article 13b of the Labor Code, or any of the prohibited practices enumerated under Section 6 of RA number 8042. This court is convinced that the prosecution was able to prove both elements of illegal recruitment in this case. Verily, the fact remains that Palasi parted with his money and his van. It is clear from his testimony that the promise made by Sakeng was what motivated him to do so. In this petition, Sakeng asserts that it was Palasi who initiated the conversation and mentioned that he was looking for work. Again, this is a factual claim that this court can no longer pass upon. Furthermore, it is evident in the instant petition that Sakeng admits having represented to Palasi that there was a job opportunity in Australia. Sakeng only denies having represented that he alone had the power to make it happen. First of all, this is another disputed fact that cannot be reviewed in this case. Second, this position by Sakeng reveals an admission confirming that he did indeed represent himself as someone who could, at the very least, process his placement for work in Australia. Finally, Sakeng makes factual issues in the instant petition regarding the inconsistencies in Palasi's testimony where he supposedly stated that he stayed in the car when they went to practice agency, but also stated later on that he went to the agency on the same date to follow up his papers. Again, factual issues have no place in reviews on certiorari. In any case, it is an established principle that inconsistencies in testimony do not necessarily affect the witness's credibility. Time and again this court has held that inconsistencies in the testimony of witnesses when referring only to minor details and collateral matters do not affect either the substance of their declaration, their veracity, or the weight of their testimony. Such inconsistencies reinforce rather than weaken their credibility and suggest that they are telling the truth. In this case, Palasi's awareness on the involvement of practice agency is immaterial. There are only 2 elements to sustain a conviction for illegal recruitment. Here, the prosecution has aptly proven that 1. Sakeng has no valid license or authority required by law to enable him to lawfully engage in the recruitment and placement of workers, and 2. That he has advertised employment abroad for profit through a placement fee. The CA did not err in finding that Sakeng is guilty for the crime of illegal recruitment. Estafa. The same set of facts that establish liability for illegal recruitment may be the basis of culpability for estafa. As held in People v. Racho, it is well established in jurisprudence that a person may be charged and convicted for both illegal recruitment and estafa. The reason, therefore, is not hard to discern. Illegal recruitment is malum prohibitum, while estafa is mala in esse. In the first, the criminal intent of the accused is not necessary for conviction. In the second, such intent is imperative. The revised penal code, as amended, provides the prohibited acts and penalty for swindling. Article 315. Swindling, estafa. Any person who shall defraud another by any of the means mentioned herein below shall be punished by 2. By means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. A. By using fictitious name, or falsely pretending to possess power, influence, qualifications, property, credit, agency, business, or imaginary transactions, or by means of other similar deceits. Jurisprudence expounds that the following elements must be established to sustain a conviction. The elements of the crime estafa under the foregoing provision are: 1. There must be a false pretense, fraudulent acts, or fraudulent means. 2. Such false pretense, fraudulent act, or fraudulent means must be made or executed prior to or simultaneously with the commission of the fraud. 3. The offended party must have relied on the false pretense, fraudulent act, or fraudulent means, and was thus induced to part with his money or property. And 4. As a result thereof, the offended party suffered damage. We agree with the CA's analysis that all the elements are present in this case. All the elements are present in this case. The false pretense by the accused appellant is glaring from his act of representing himself as someone who could help the private complainant work in a farm in Australia, when in truth and in fact, he possessed no such power to make it happen. The private complainant agreed to part with his van and money as payment for the placement fee, believing in good faith on the accused appellant's misrepresentation. Such reliance is evident by the fact that the private complainant went to practice agency to follow up his papers, being under the belief that the accused appellant submitted them with the said agency. It is necessary to prove the element of damage in a case for estafa. Upon review of the testimonies of the witnesses, the court finds that the same has been sufficiently established by the positive testimony of the private complainant. This warrants the conviction of the accused appellant, even without the presentation of the receipts for the payment of the placement fee. For these reasons, the petition is denied. The Court of Appeals decision dated September 9, 2020 and resolution dated July 22, 2021 in CAGR number 40287 are affirmed with modifications. Lee Sakang Y. Anaban alias Lee Sakang Sanaban is guilty beyond reasonable doubt of the following crimes and shall suffer the following penalties. 1. In criminal case number 14, CR 10149, Lee Sakang Y. Anaban is guilty beyond reasonable doubt of the crime of illegal recruitment defined and penalized under Sections 6 and 7 of Republic Act No. 8042, as amended by Republic Act No. 10022. He is hereby sentenced to suffer an indeterminate penalty of imprisonment of 12 years and 1 day, as minimum, to 14 years, as maximum, and to pay a fine of 1 million pesos, and 2. In criminal case number 14, CR 10150, Lee Sakang Y. Anaban is guilty beyond reasonable doubt of the crime of estafa defined and penalized under Article 315, Paragraph 2A of the Revised Penal Code, as amended by Republic Act No. 10951, and is hereby sentenced to suffer the penalty of imprisonment of 2 months and 1 day of arresto mayor, as minimum, to 1 year and 1 day of prison correctional, as maximum. He is likewise ordered to pay Jan Denver Palasi the amount of 85,000 pesos, Sakang v. People, GR number 257805, April 12, 2023, with legal interest at the rate of 6% per annum from the filing of the information until finality of this decision. Finally, the total amount of the foregoing shall earn interest at the rate of 6% per annum from finality of this decision until full payment.